of today's protest, I feel like, would be just to say his name.
Yes, sir, Nolan Wells.
For me, this means a whole lot because I have my kids in this community too.
Hey, Nolan Wells.
I'm a mom. I have 2 sons, so it hit home for me.
Hundreds of people, one street corner, one name. On Saturday evening, the intersection of government and state streets in downtown Ocean Springs filled up. Signs, flags, prayers, all of it for Nolan Wells. They weren't there because of what they know. They were there because of what nobody will tell them. But here's what most of that crowd didn't realize. While they were standing on that corner, a former Mississippi judge, a man who spent 6.5 years signing arrest warrants and search warrants in this exact state, went on camera and said the thing no official in this case has been willing to say. In his opinion, an arrest should have already happened. Not someday, not after the autopsy, now. And he named the exact charge he would have signed off on himself. His argument is sharper than anything we've heard so far. It's narrow, it's specific, and it doesn't require solving the biggest question in this case at all. But there's a problem. Because days after he made that argument, one of the people who was actually on that island stepped forward. And what he said pulls at the single thread the judge's strongest theory hangs on. We'll get to him. First, the crowd.
The community in Ocean Springs, Mississippi, is still reeling from the loss of a beloved community member, coming together for a peaceful protest to demand justice for 18-year-old Nolan Wells. Just 1 week after he went to Horn Island to celebrate the 4th of July with friends and never came home.
If you've been following this case, you already know how we got here. 18-year-old Nolan Wells, a 4th of July boat trip to Horn Island, friends who came back, a young man who didn't, and a body recovered from the water 2 days later with no official cause of death released to this day. What's new is what that silence is producing. The protest started around 5 p.m. Saturday. Local news put the crowd at several hundred. And this wasn't one demographic, one age group, one circle of family friends. Teenagers stood next to grandparents. People who knew Nolan his whole life stood next to people who never met him at all. At one point, members of Israel United in Christ marched down Government Street and folded back into the crowd. The day before, at a press conference, Nolan's mother, Christine Wansley, asked for exactly this. She asked people to keep it peaceful. She said her son didn't like fights, he didn't even like arguments. She asked the crowd to carry themselves the way Nolan would have wanted. And they did. 19-year-old Nicholas Madison said the whole point of the day was simple. Make sure people say Nolan's name. Quanta Green, a mother of 2 sons, said the case hit home the moment she heard it. Biloxi resident Gordon Jackson said Nolan could easily have been his own grandson. And then he said something heavier, that this isn't the first time. That there's been a long, historic stream of young black men losing their lives under suspicious circumstances. But the voice that stays with you belongs to Jaron Lowry. Lowry's daughter played basketball with Nolan when they were kids. Years later, Nolan came to him looking for work at his business renting water slides and bounce houses. Lowry remembers what the kid told him. My mom and dad said I've got to earn my own money. Lowry told him to make good choices when he got to college. To set himself up for a lifetime. Nolan's answer was 2 words, yes, sir. Lowry says that kind of respect is rare now. He says it tells you everything about how Nolan was raised. And then he said the line that cuts through all the noise around this case. It's not about the color of anyone's skin, it's about the facts, whatever they turn out to be. If this was a mistake, he said, then say so. Talk about it honestly. Just let the truth come out. He ended by speaking to Nolan directly. Rest in peace, man. You did everything you could while you were here. And you did a good job of it. Several hundred people, 0 arrests, 0 incidents. Exactly what a grieving mother asked for. Now, why were they out there at all? Because this protest didn't happen after an answer. It happened inside the space where an answer should be. Here's the official record as it stands. Jackson County Coroner Bruce Lind has confirmed there were no immediate, obvious signs of foul play or trauma on Nolan's body. But listen to what he did next. Because of the uncertain circumstances, the coroner himself sent the body to the state medical examiner's office for a full autopsy, specifically to determine whether there was any trauma or foul play at all. Those results, including the cause and manner of death, are still not released. They're waiting on toxicology, and toxicology takes time, days, sometimes weeks. Understand what that means. A preliminary examination rules out the obvious: gunshot wounds, stab wounds, severe blunt force. It cannot rule out what toxicology and a full internal examination exist to find. So when you hear no preliminary signs of foul play, that is not a conclusion. That is a starting point. An enormous amount of ground is still uncovered, and both autopsies, the state's and the independent one, the family commissioned in Washington, D.C., are designed to cover it. The family didn't stop at a second autopsy, by the way. They had Nolan's body flown out of Mississippi entirely because they wanted a doctor with no ties to Mississippi law enforcement anywhere near it. Colin Kaepernick helped fund that examination. Tyler Perry is covering the funeral. That's how far this case has traveled, and there's one more detail sitting in the timeline that the crowd on that corner has not forgotten. A friend called the Coast Guard about Nolan around 11 p.m. on July 4th. His mother reported him missing around midnight. The sheriff's office did not request Coast Guard assistance until around noon the next day, 11 at night, to noon the next day. The timestamps speak for themselves. Into that silence, into that exact gap between a preliminary, nothing obvious, and a final answer that still hasn't come, stepped a man who used to be the one deciding when the paperwork was enough. Carlos Moore is a former Mississippi municipal court judge. By his own account, he spent 6.5 years on the bench, signing search warrants, signing arrest warrants, presiding over initial appearances and preliminary hearings. Nearly a quarter century in the legal field overall. He also says he was ultimately pushed off that bench after speaking out against racial discrimination while still serving. So when he talks, he's not guessing at how this system works from the outside. He was the system's signature line. And in a public video running over half an hour, Moore laid out, piece by piece, why he believes this investigation is not moving the way a serious one should. Start with the words. Moore says the sheriff's early statement that no foul play was suspected was simply the wrong sentence. The fair one, the accurate one, was that it's too early to say either way. And he's not alone in that critique. Even a national law enforcement analyst reviewing this case said that phrasing may have been a poor choice of words that fed the misunderstanding. Words shape whether the public believes an investigation is serious. In Moore's assessment, nothing about the surrounding behavior in this case supported that level of certainty that early. Then, the pace. Moore argues that by this point, there should already be search warrants on file, evidence formally submitted to a judge, subpoenas issued for the social media accounts of the friends who were on that trip. Formal, sworn interviews, not informal conversations. He's even argued the boat itself should have been seized as evidence before anyone had the chance to clean it or rent it out again. In his words, this is what the process looks like when a thorough investigation is actually underway. That's not speculation about what happened on the island. That's a former warrant signer describing standard procedure and saying he doesn't see it. Then he went further. Moore listed the behaviors that, stacked together, cross a line for him. Reports that the friends were seen having breakfast the next morning instead of searching. Deleted and deactivated social media accounts. The strange episode with the car keys, reportedly missing, then suddenly found. And legal representation secured remarkably early, before Nolan's body had even been recovered. In Moore's reading, that stack should move these young men from persons of interest to formal suspects.
I may have been born at night, but I was not born last night. And one thing about it, you cannot fool the informed. I've been on the inside. I know the process, and we will not sit quietly and allow this to be swept under the rug.
To be clear, that is his opinion. No investigator, no prosecutor, no sitting judge with authority over this case has made that classification. Every one of those details has been reported separately. The interpretation is Moore's alone. But then came his centerpiece. The argument the whole video builds to. And it's not about murder at all. It's about a phone. You've seen the viral video. Everyone following this case has. And in it, a voice, widely believed at the time to be Nolan's, can reportedly be heard demanding his phone back. Moore's logic runs like this. If Nolan, in his own words, while he was still alive, did not give whoever had that phone permission to keep it, and that person kept it anyway, that is potentially theft. Full stop. It doesn't require an autopsy. It doesn't require a theory of how he died. It's the smallest, most immediate legal question in the entire case. Who had that phone without permission? And why? And Moore said it plainly. If an affidavit reflecting exactly that had crossed his desk while he was still on the bench, he would have signed the arrest warrant himself for theft of the phone, based on what's already public. That's the answer to the question in this video's title. The judge isn't calling for a murder arrest. He's saying investigators are so busy staring at the biggest possible charge that they've walked right past the smallest provable one, sitting in plain sight. Here's what makes that phone even stranger. The sheriff has confirmed on national television that Nolan's phone still has not been turned over to investigators. His words. It may be a piece we haven't got yet. Moore has separately claimed the family tracked that phone to a friend's home. More than a week after Nolan disappeared, one of the most important objects in this case is still unaccounted for. Moore raised bigger questions too, whether the Justice Department's Civil Rights Division, the FBI, or the Mississippi Bureau of Investigation should step in. Given the concerns about whether local law enforcement can run this without bias, he invoked Emmett Till directly, noting that nobody was ever held accountable for that killing despite overwhelming evidence, and said he hopes a Mississippi jury today would do better if the facts here support charges. He even said he no longer calls Mississippi a great state and wouldn't recommend anyone raise a family there. And credit where it's due, Moore was consistent about one thing. He is not calling for a rush to a murder charge. He said the most serious charges must wait for actual evidence. Both autopsies, the body examined for any bruising or injury, witness statements gathered properly in affidavit form. And he walked through what follows even if an arrest ever comes: arraignment, bail, preliminary hearing, grand jury, trial, a unanimous verdict, or a hung jury, and the whole thing starts again. His point was blunt. Even an arrest wouldn't be an ending. It would barely be a beginning. So that's the argument. A former judge, on the record, under his own name, saying an arrest warrant for that phone should already exist. Except, remember the thread I told you about at the start? The one his strongest theory hangs on? Someone just pulled it. Days after Moore's commentary spread, one of Nolan's closest friends went on national television. His name is Trakestein Shepard. He was on Horn Island that day. And he says the yelling voice in that viral video, the video the whole internet has been dissecting, the one at the center of the theft argument, wasn't Nolan's. It was his. That's the video I'm referring to. Shepard told Good Morning America. And that's me yelling. Some independent breakdowns of the footage now question whether Nolan is even in the frame at all. Sit with what that does and what it doesn't. It does not prove nothing happened on that island. It does not explain why Nolan's phone still hasn't reached investigators. That question is alive and open. And it doesn't touch Moore's critiques of the investigation's pace and language. Those stand on their own, video or no video. But if the voice demanding a phone back wasn't Nolan's, then the cleanest arrest theory in this case was built on a premise a named eyewitness now publicly disputes. In one interview, the ground shifted under it. That's how fast everybody knows can dissolve in a case built, so far, on fragments. Shepard himself put it about as honestly as anyone has. Let the investigation continue, he said. If the facts show somebody harmed Nolan, he wants justice. If it was a tragic accident and somebody stayed silent, he still wants justice. Either way, in his words, I just know I've lost my best friend. And as of Monday, here's where the official side stands. Sheriff John Ledbetter says the investigation is active and ongoing. Witness interviews have been conducted. His office is working in tandem with the district attorney, which, he stressed, does not by itself mean a crime occurred. And notably, he confirmed his department has been in contact with other agencies, including the FBI. The public call for photos and videos, he says, has been very productive. Every rumor, including questions about drinking on the island that day, which Shepard himself has acknowledged, is being run down. That's a partial answer to Moore's federal question. Contact isn't a takeover, but it's no longer nothing. Step back and look at the symmetry. A crowd of several hundred ordinary people, no legal training, no inside knowledge, stood on a street corner because something about this case felt wrong enough that showing up mattered.
We're going to stand behind the family, and that's why we're out here.
No peace!
A lot of times, these stories go unnoticed.
Because Nolan Wells is not the only one. There has been a long historic string of young black men losing their life under very suspicious circumstances.
A former judge with decades of training and first-hand experience signing these exact warrants looked at the same facts and landed in the same place. Neither offered proof of what happened to Nolan Wells. Both offered a demand that the process move with the seriousness this case deserves. Now, before we go, let's be precise about what you just heard. Carlos Moore's remarks are one credentialed attorney's legal analysis and personal opinion, offered publicly under his own name. They are not evidence. They are not charges. And parts of them, by his own admission, are speculation. No one in that friend group has been named a suspect or charged with anything. At one point, Moore even speculated aloud about whether a parent connected to this case could be an accessory. And we are deliberately not repeating who he meant, because an unproven allegation against a private, uncharged individual is not something this channel will amplify. Raising a question is not the same as establishing a fact, and the cause and manner of Nolan's death remain officially undetermined until both autopsies are released. So here's what we're watching next. The state autopsy, the independent autopsy, the phone. Whether anyone's formal status in this investigation changes, and whether federal contact becomes federal involvement. We'll bring you the facts as they're confirmed, not a moment before. If you want the autopsy results the moment they drop, please subscribe so you don't miss the next update on this case. Thank you for watching, and we'll see you in the next one.